You're live.
Okay, thanks. I've learned not to jump the gun on that anymore. Okay, here, this is the Board of Adjustment meeting. It's May 14th, 2026 at 6 o'clock. If we can go ahead and stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with justice for all.
Okay, to go ahead and start with introductions. Gonna start on this end.
David Shuey.
Randy Wise.
I'm Julie Johnson, chairperson,
David Vogt.
and Mr.
Richard
Forsyth.
Forsyth, special counsel.
Thank you. We also have in attendance Bill Zolber, our town manager, and our town solicitor, Fred Townsend, as well as interested parties for these proceedings. First item on the, well, not first item on the agenda, but next item on the agenda is the approval of minutes. Did everyone have a chance to look at the minutes from our last meeting? Yeah. Do I have a motion to approve the minutes?
Motion.
Second. Okay, all in favor? Aye. Okay. And then next, the adoption of tonight's agenda, which is very similar to our agenda from 2 weeks ago. Do I have a motion to adopt the agenda?
Motion to adopt.
Second?
Second.
All in favor?
Aye.
Mr. Weiss?
Yeah, I'd like to make a motion to adjourn for an executive session, please.
To discuss legal issues?
Yes, this legal issues.
Do I have a second?
Second.
Okay.
Second.
All in favor?
Aye.
Aye.
Okay. We're closing the executive session. Mr. Morrison?
So the board went into executive session to discuss certain procedural issues, but because they involved some legal question, that's why we were in executive session. The first question that and the board did not reach any conclusions. So the first question that we discussed was whether Mr. Shuey, who was not physically present 2 weeks ago, can now participate. He has reviewed he was on for part of the video towards the end 2 weeks ago. He's gone back, he's reviewed everything, he's reviewed all the submissions, but he was not present, I'll say live, for 2 weeks ago. And so the question before the board is whether Mr. Shuey should participate or not. The board's rules are silent on the issue one way or the other.
Does anybody have any thoughts on it?
Like we probably should not.
I added an abundance of caution because Dave wasn't live. My thought is that he not participate in the appeal portion. If we get to the exception portion, then he would be able to participate in that. Your thoughts?
I agree with you.
All right, so we need a motion now.
A motion for Dave to not be involved.
For the first part.
For the first part,
Do
correct.
I have a second? Second?
Okay.
Okay. All in favor? Are you seconding? Sorry. All in favor? Aye. Opposed? You can, you're allowed to vote.
Yeah, you can vote yourself out.
3-1. Mr. Shuey is going to not participate with regard to this first agenda or the appeal issue. If we get to the exception, then he will be able to vote or participate fully and vote on any decision.
Recorded.
Okay, the second procedural issue that we discussed in executive session was, it may seem silly, but whether we should allow a brief statement from each of the two attorneys before deliberations begin. Folks may recall that 2 weeks ago when we adjourned, the attorneys had completed their presentations and their summations, but it has been 2 weeks. And so the question is whether we should allow just a brief kind of refresher or summation now. If so, should it be limited to some period of time, 3 or 5 minutes? And if we do limit it to some period of time, I'm going to be timing you, and when the bell goes off, you're out of time. But that's where we are.
So my thoughts are that just as a refresher, because it has been 2 weeks, even though I know myself personally, I reviewed everything again, like re-reviewed everything again today, made some additional notes based on the notes that I had taken during the hearing. I think a 5-minute summation from each side would be beneficial, and also for anybody who maybe is watching online or is here today that wasn't present 2 weeks ago, gets kind of caught up on where we are.
Motion for that. Motion.
Okay, do we need to officially vote on that, or can we just?
Yeah, might as well.
Okay,
Motion for summation.
Second.
okay, all in favor?
All right, 5 minutes, correct?
Yes, 5
Okay,
minutes.
5 minutes max, so
You don't have to.
plan
use it all.
accordingly.
Could I ask one question to the board? Is it possible for us to do that after we determine what we're going to do about public comment and then do it after public comment in case we want to add anything about the public
So the
comment?
third thing we were about to
Yeah.
discuss was public comment. So the final issue is whether public comment should be permitted or not. This is a kind of a legal question before the board. It's not your typical variance request. It's not your typical exception request. There's a legal dispute about whether this provision, one of the provisions of the code, was properly interpreted or not, or applied by the town. Historically, in these sorts of proceedings, public comment is not permitted, just like the public comment isn't permitted in a criminal trial or a civil trial, right? I mean, you've got the parties, they're in front of the judge, they're in front of the jury, and the general public doesn't get to act as interlopers. Having said that, the Freedom of Information Act was recently amended a few years ago. I think it's created an unintentional conflict because the amendment says that public comment shall be provided as part of every public body meeting, meaningful. In fact, it even uses the word meaningful, whatever that means. And, but it says the public body can, is subject to rules as the public body may want to put in place. So right now we are in, I'll say, the appeal portion of this proceeding. If there was going to be public comment, it would be limited solely to the legal issues presented and subject to, I think you all have a 3-minute time limit anyway. But the question is, do you want to allow for public comment or not? And that's what you need to decide.
I'm fine with any public comment. I will say that the public comments that we've gotten through email, through the town have all addressed the exception issue. None of them have addressed the legal issue. But if anybody, I'm open to allowing public comment to the limited issue of the application of the code by the town. Guys, thoughts? And I would ask that if anyone if anyone wants to make public comment on that issue and they start to kind of get into the exception, we're gonna cut them off and their time is out regardless of how long they've been speaking. Any thoughts?
So public comment is allowed on the legal issue?
It is, but only on the legal
Okay,
issue, and if we get to the exception, then we'll talk about the public comments that we've gotten through email, and anybody who's present either online or present here physically has a public comment to make if we get there.
So again, someone want to make a motion?
Yeah, motion to allow public.
Okay, all in favor? Aye, okay.
All right, and then I guess the last wrinkle, maybe we did this out of order, but the suggestion has been we have public comment before the summation.
I'm fine with that.
Okay, so we want to make a motion. I think that's, yeah,
Let's-
we'll let the chair have the prerogative there.
I'm fine.
So having said that, next on the agenda, we would have any public comment on the appeal of the decision of the building official pursuant to section 185-66 of the Dewey Code. Public comment is limited to 3 minutes. We will time you, but it is limited to the legal issues that were presented and discussed at the prior meeting. If you stray into your thoughts or opinion about the special exception and what standards apply there, you would be ruled out of order because that's not appropriate at this stage of the proceeding. If we get to the special exception, then of course you're free to talk about that all you want. So with that, is there anybody who wishes to address the board from the public on the legal issue?
Gentlemen, I see you in the back. Do you have any comment to make?
I guess we'll wait for if we get to the exception.
Okay. Is there anybody online, Kate?
No one is reaching out in chat. Oh, yes, we do.
Okay.
I'm not mic'd. Can you tell him to go ahead? It's David Moskowitz.
Mr. Moskowitz, go ahead.
Yeah, David Moskowitz, full-time resident, Dewey Beach. The building permit for Marsha's Pool was already approved. Attempting to pull it back now is wrong and raises serious fairness and due process concerns. Because public comment for the portion of the hearing is being limited to legal interpretation of the code, I want to focus specifically on the town's interpretation and enforcement of 185-51A and related ornamental fence height requirements. The town's current interpretation does not appear to be applied consistently. There are numerous existing conditions throughout Dewey Beach that would appear to conflict with the interpretation now being inserted, including what I believe are over 100 existing examples involving 185-51A issues, front yard pool configurations, and fence height situations. If there truly was a clear zoning issue, then why is the town simultaneously rushing to change the zoning process and ordinances? That suggests the current code did not prohibit what was approved. And zoning is not supposed to be a popularity contest, as it was showed at the last meeting, but I feel like this is targeting an individual. I reviewed Marsha's submission and the neighborhood comparison report that was submitted earlier by her to planning and zoning. If it has not already been entered into the record, I would like it incorporated as part of my public comment. I asked Marsha to have handouts on my behalf as part of the comment that she could give the board. I can also email it if needed. The materials demonstrated that the proposed pool would not be inconsistent with the neighborhood. There are already pools located in front yard areas in town.
Excuse me, Mr. Moskowitz, is it? we're talking about the legal issue only at this point, and now I think you're straying into whether it makes sense to grant an special exception.
No. I have 2 more paragraphs, and it's all about the legal issue.
All right, you've got,
If you would,
you've got 60 seconds.
as you have said at the last meeting, you don't have to take it into evidence, but it would be nice if you could listen to 2 paragraphs. There are already pools located in the front yard areas in town, including at my complex, which include 26 McKinley, where the board chair has personally visited during my family gatherings. We were allowed to replace our fence last year with the town issued a permit, and again, it's in the front yard. Town had no issue. The idea that this proposal is somehow unprecedented or incompatible with the neighborhood is simply not consistent with existing conditions in Dewey Beach. And again, if I am not permitted to address some of these broader consistency and neighborhood issues during this portion of the hearing, I would be also, I ask that it's considered during the open public comment of the next hearing as well. But I would like for the exhibit I referenced to be entered into evidence. Thank you.
All right, thank you. Is there anybody else who has public comment who's online?
Doesn't look like it.
Okay. So I'm going to reset my stopwatch, and you each have 5 minutes to present a brief summation on the legal issue. And we'll start with the appellant.
Thank you. Thank you, members of the board.
You can either sit there or if you want to come up to the podium, your choice.
Do you mind if I sit?
That's fine.
Thank you. Can you hear me? Thank you. We appreciate your time and attention to this matter and so diligently addressing the procedural issues this afternoon, I guess I should say, or evening. So I just want to refresh your recollection, why we're here. We're here for an appeal of the denial of a pool permit. And the grounds that the pool permit was denied was on the basis for non-compliance with 185-51A and 185-92A2 of the code. So those were the sole grounds for denial, okay? I think since I only have 5 minutes, I think what I really want to bring to your attention, and I believe it was just raised by Mr. Moskowitz as well, is that in Exhibit 10 to the documents that we submitted that are part of the record for this hearing, you have an ordinance that was introduced by the Town Council on April 17, 2026. And the intent of that ordinance was clearly to prohibit 4.5-foot safety fences in the front yard setback for properties in Dewey Beach. I think that ordinance in and of itself says everything you need to know. What that tells you is that the existing ordinance did not preclude 4.5 safety fences in the front yard setback, okay? And the reason that ordinance was submitted was either because the ordinance didn't preclude it or was very clear that it was very ambiguous. Now, the town is asking you to say that the burden of the ambiguity falls on the applicant, Ms. Scheck, or 101 Carolina, and we submit to you that that is contrary to 100 years of law that says when there is an ambiguity, you find in favor of the landowner. And the reason the law says that is because the reason that an ambiguity is resolved in favor of a citizen because the law recognizes that it is there to protect the citizen. It's not there to protect the government or the mob. And that's why the law needs to be clear. And in this case, the law was clear to my client because in 2013, she got a pool in her front yard at 114 Chesapeake. At that time, the town did not sue her to enforce the law. They didn't take the code section to a court to say, hey, determine whether or not this code section is valid, all right? Nor did they change the law until April 17th, 2026. So the town is clearly acquiesced to the fact that pools were permitted in the front yard. The only other thing I want to note is that the town also makes the argument, well, we changed an ordinance in 2014 for green space that now precludes the interpretation of allowing a fence in the front yard setback. And that ordinance has been interpreted in a manner that is not consistent throughout. They still allow things that they still allow porches, terraces, HVAC systems by their own admission. Those are still allowed. So the town cannot argue that, oh, that section precludes a pool, but it doesn't preclude these other things because it reads what it reads. So it's a matter of the selective interpretation by the town. And we just submit to you that Ms. Scheck should not be required to give up her rights. These are her property rights. They were her property rights in 2013. And the burden should be on the town to make laws clear that if they're going to preclude the use of your property, that law needs to be clear. And it wasn't in this case. And it certainly did not preclude a 4.5 safety fence in the front yard. Thank you.
All right, thank you. Mr. Townsend.
Let's see if I can scoot this out a little bit without turning it over. Pardon me. Okay. Well, I thought my time before you was over, and I find myself back up here again.
Yes.
Sorry about that. I apologize to you all for that. I would say just as, you know, wearing another hat, it's probably not appropriate. I think Mr. Shuey, when the deliberations begin, should probably take a seat in the audience, so there's no argument that he's playing any role in the deliberations over this, and then he can resume his seat when and if we get to the next issue. A couple of things that were just said by the public that I want to address very quickly. The building permit was never issued. There was no building permit issued. And even if it had been issued, if it was issued inappropriately, there'd be no reason for the law would not support that permit would have vested rights in the applicant. The law is that an illegal permit is not valid and can be revoked or can be rescinded. Of course, that permit was never issued. When a permit's issued, then you can break ground, then you can begin. That never happened. There are a couple pools that have been brought to our attention that exist in the town that arguably are in a front yard other than the one at Chesapeake Street. The second one that was recently approved, I think, on Carolina Street, at 11 Carolina Street, and I showed you pictures of that, if you recall. That was approved pursuant to our interpretation of the code, which is consistent with the present interpretation of the code. But those were site plan approved condos, which were reviewed and approved, and the law associated with the area restrictions applicable to those pools was established by the site plan. It's hard to say whether the pools are in the front yard or in the side yard. It's that one condo in particular is bordering on three streets. So I don't think that condo pool, for instance, and maybe there's another one, bears any resemblance to the current predicament that we're in, and shouldn't be persuasive in any way. And then next, why are we here? We've got two ordinances that we're asking you to apply to the swimming pool fence that's proposed in the required front yard. There's 185-51A and 185-92B2, both saying that you can't have a fence in the required front yard above 3.5 feet. That's the problem that we have here. Now, the applicant is arguing that 185-51B should be interpreted in such a way that a swimming pool, can be located in any required yard with limitations applicable to the side and rear yard, but no limitations applicable to the front yard. Your challenge is, you need to ask yourself whether that is a reasonable interpretation. If you find that it's not a reasonable interpretation, then you reject it, and you can't then come to a conclusion that a swimming pool can be located in the required front yard. Now, the applicant is not even asking to put a swimming pool in the required front yard. They're just simply making an argument that, well, if a swimming pool can be located in the front yard, then so can a fence. We don't really even have a swimming pool in the required front yard now. So given you a theory for why that curiously worded language can be interpreted the way the appellant wants it interpreted. You don't have to accept that. When you find language in the code under the rules of statutory construction that is curious or somewhat uncertain, you don't give up. The rules require you to ask whether you can reconcile both interpretations against existing code provisions. I think you cannot reconcile their interpretation with the remaining provisions of 18551B. You can't reconcile it with the two provisions relating to 3.5-foot fences in required front yards. That's 51A and 92B2. You also can't reconcile it with the green space ordinance, which was adopted in 2024. I think the applicant mistakenly said 2014. That's irrelevant. It was 2024. That says what can be in a required front yard. You can't have a pool in a required front yard. And you're in the course of doing your statutory interpretation duties, you're to ask whether there are any absurd results that would flow from one or the other of the readings. And one of those is that there's no fence height restriction, maximum fence height restriction applicable to a swimming pool fence, only a minimum. So if that's the case, then the only applicable height restriction that would apply to this proposed fence would be 35
Mr.
feet.
Townsend, you are past your 5 minutes. I
Okay.
appreciate
Thank you.
your comments.
Thank you all.
I should have done this before their summations, but I'm officially closing the open hearing, the public hearings. Sorry, I forgot to do that before your summations, but, so the public hearing is officially closed and discussion for the board. Ready? Oh, sorry, you're retreating.
Thank you, Mr. Shooter.
Thanks.
So, and just to sum up here, so you understand what's going on. So there are certain provisions of the zoning code, and the law is, as has been said by both sides, if a zoning code provision is ambiguous, then it is to be interpreted in favor of the property owner, and I think Ms. Faust put it eloquently. I mean, that rule exists to protect property rights and property owners, and requires a certain degree of precision in drafting codes. But having said that, a code provision is only ambiguous if it is reasonably susceptible of two interpretations, right? So just because you may think something's ambiguous doesn't mean it is. You have to be able to come up with more than one reasonable interpretation in order for it to be ambiguous. So I would suggest if the code provision at issue here that everybody is focused on is 51B, 185-51B, and this appears as exhibit, what is
Exhibit A.
it? I mean, it's attached to your, it's exhibit A to the town's submission. They have the provision of the zoning code. It says accessory swimming pools, open and unenclosed, may occupy a required yard or side yard, provided they are not located closer than 10 feet to an interior side lot line or 6 feet to a rear lot line. And then it talks about a walk space at least 3 feet wide has to be around the pool and the fence. And it says every swimming pool must be protected by a safety fence not less than 4.5 feet in height. And the reason that there's at least some confusion or argument here is because in the first part of that sentence, in part B, it says may occupy a required yard or side yard. And then in the second part of the sentence, it talks about 10 feet to an interior side lot line or 6 feet to a rear lot line. So on the one hand, in the first sentence, it says yard or side yard. And in the second part of that sentence, it says side or rear. And the argument, I think, is the suggested ambiguity is when it says a required yard, that means it could be a required front yard or a required rear yard, or perhaps even side yard. But then the next It says or side yard, so do you interpret that to mean yard could mean any yard, or do you interpret that to mean, since the second part of the sentence says side or rear, that simply the word rear was missing? And are both of those interpretations reasonable? Is only one of those interpretations reasonable? So welcome to the world of
Yeah.
statutory
Well,
interpretation.
I looked at this pretty closely, and in 1983, with the initial code, it said rear or side yard. In 2009, we found out, for whatever reason, the word rear came out. But I think, in reading it, as you were pointing out, that it's 10 feet to an interior side lot line or 6 feet to a rear lot line. It doesn't mention anything about where it should or should not be located closer to. So to me, I feel it's clear if you read the whole sentence and not just focusing on the fact that required yard, the word rear, that used to be in the code, is missing. So that was the thing that popped out to me, because if they really did mean it to be any yard, then why doesn't it say how many feet it should be in a front yard? And that is something that really stood out for me as I was reviewing all of this. Randy, your thoughts?
Well, this ambiguous town code favoring the landowners is new to me. It's first tonight. But I don't think that the town code being ambiguous, if it is or isn't, I don't think it's unknown to Ms. Scheck, because she went through this thing 10 years ago, and she's built, or redone about 20 of these cottages. And if anybody's familiar with the town code, other than the attorneys, I'm sure Ms. Scheck is. So the hardship, I think, on this thing that,
Well, let me
We're
stop you.
not doing with hardships.
The issue here, and whatever experience Ms. Scheck may have had elsewhere in town, is not relevant. The question before you, and I'm going to say phase one, and might be the only phase, is whether or not you think this sentence has two reasonable meanings. And if it does, then the meaning that supports the appellant should be, as a matter of Delaware law, is the one you should follow. If you think there's only one reasonable meaning and it doesn't support the appellant, then that's the meaning you go with. So the question is, and Ms. Johnson has already kind of said what she thinks, the question is, do you think that this language could be fairly read to include allowing fences in a front yard?
it doesn't address the front yard.
So,
It doesn't address the front yard. So whether front yard comes into play with what, it doesn't say it. So there's nothing there to either be read this way or that way. I mean, if I be pinned to that, it's like, nah.
Okay.
Dave, your thoughts?
It does not say anything about a front yard, it just says 6 foot to a rear lot.
Can you
Can you speak
speak
up?
in
Oh, I'm sorry, I'm just
We're
kind of,
being recorded, he's mulling it over.
I'm trying to think about this. But I kind of agree with Julie about the second part of this, part B, yes. That it doesn't say anything about a front yard, it does say rear lot line and side yard, but nothing about the front yard. So that does stand out there, and it doesn't say anything about a front yard.
Well, and I think the other
Just the-
chapter well, no, but the other reason that the town denied the permit was 18592, which is very clear about having no more than 3.5 foot in the front. So that to me is
Another reason.
not, so in my opinion, I feel like the town has appropriately applied the zoning, the two chapters that we've been discussing. And based on that, I would deny the appeal. For the reasons I've previously stated. I guess I'm gonna go ahead and make a motion since I did most of the talking. I make a motion to deny the appeal for the reasons I stated about I don't feel it's an ambiguous section based on the fact that it's very clear about where the 10 feet to an interior side lot line or 6 feet to a rear lot line. When you read the sentence as a whole, instead of just focusing on the absence of rear in that sentence, which the town has now corrected because of realizing that it was an issue, but I don't see it as an issue given the fact that, as I said, reading it as a whole, it is. And then obviously, as I said, 18592, which is the other reason that the permit was denied, is crystal clear about not having anything higher than 3.5 feet fences in the front yard setback. So my motion is to deny that appeal. Yes, do you have a second?
Second.
All in favor? Aye. So,
Okay. So the town's decision has been upheld. The second part of the appellant's presentation here, in addition to challenging that decision, they also asked for a special exception. And so we will move to that portion of the proceedings.
and before, just so we have them in mind, Ms. Fort, can you, because we usually deal with variances and not special exceptions, so can you remind the board? And Mr. Shuey, you can come back and join us. Can you just remind the board of the qualifications and what the standards are for an
Yeah,
exception?
I'm sorry, I planned to do that, so I appreciate you
That's
reminding me.
okay. I just want to make, because we all have variances on the brain most of the time on this board, so I just want to make sure that we're all clear about the standards before they give the presentation, so we can have those things in mind as they give them.
So unlike a lot of other zoning codes, which clearly throughout the state allow for variances, and in fact Delaware law requires that every zoning code provide for variances, the Town of Dewey Beach Code also includes a section entitled Special Exceptions. That section begins as follows in 67A, quote, "In order to provide for adjustments in the relative location of uses and buildings to promote the usefulness of these regulations and to supply the necessary elasticity to their efficient operation, special use exceptions and, limited as to locations described in this article, special yard and height exceptions are permitted by the terms of these regulations. The following buildings and uses are permitted as special exceptions if the Board of Adjustment finds that, in its opinion, as a matter of fact, such exceptions," and this is the important language now, "will not substantially affect adversely the uses of adjacent and neighboring property," end quote. So the code directs you to grant a special exception, but only if you find such exceptions will not substantially affect adversely the uses of adjacent and neighboring property. And then it goes on to say that special yard exceptions may be granted by the Board of Adjustment to allow, in special circumstances, the installation of pergolas, gazebos, swimming pool auxiliary buildings, and similar incidental structures in the yard setback area in any district, but not closer than 3 feet to a property line. So what the applicant, although she can correct me if I'm wrong, but what the applicant is seeking here is a special exception to put in a fence that, rather than 3 feet, is 4.5 feet tall. And again, the standard for you to grant that is you would find that such a 4.5 foot tall fence, as compared to 3 feet, will not substantially affect adversely the uses of adjacent and neighboring property. So it's a little bit of a mouthful, but that's what it is. Will not substantially affect adversely the uses of adjacent and neighboring property.
And then the second part of that is what I was more unclear to me about the pergola what's the 3 feet to the property line? So it has to be,
Not closer than 3 feet to a property line. So, the limitation on front yard fences is 3 feet. You can only grant a special exception for a fence that's taller. I'm sorry.
but I think we're talking about 3.5 feet tall, but I guess where I'm confused is 3 feet.
3 feet to the front property line.
To the front property.
'Cause
line.
this
Well,
is-
any property line.
Well,
really.
this is a special yard exception for the front
Yeah,
yard.
but here we're dealing with the front yard, so
Yeah.
you could grant a special exception for a taller fence as long as it was more than 3 feet from the front property line.
Okay.
Which I understand the fence here is.
Is 10 feet, correct.
Okay, that's,
So
I just wanted to make sure I was clear.
So it's in the area that you could grant a special exception, as I've said many times, and it's a tongue twister. You have to find that additional height will not substantially affect adversely the uses of adjacent and neighboring property. So it's a little different than a variance,
Right.
but it is what it is. And so with that, why don't we have just a very brief introductory statement from each side, so we can kind of set the tone for this, and then we'll let the appellant put on her, or the applicant now, put on her case. So Veronica.
So, and I'm just gonna,
So you want me to start?
Yeah, why don't you just give us a two or three.
just for the record, before you do that, I'm just gonna read from what the special yard exception is, just so we have it now that we're opening the public hearing, and we'll hear your comments. So this is a request for a special yard exception from 185-51A and 185-92A2 of the Code of the Town of Dewey Beach to allow the construction of a 4 1/2 foot pool safety fence in the 18-foot front yard setback as such height exceeds the maximum allowable fence height and of 3.5 feet permitted within the front yard setback. So with that,
Thank you. Thank you, members of the board. So again, we are here tonight for a request of a special yard exception for the 4.5-foot pool safety fence in accordance with section 185-67C of the code. In connection with this matter, we had submitted a legal argument to the town, and that supplemented our application, and that legal argument set forth the rationale for why this matter is appropriate for a special exception. The applicant is, her pool that she will be presenting testimony that the pool is inside the buildable envelope. So she is seeking a special exception for her 4.5 foot safety fence. 185-67 allows, under special circumstances, accessory structures and similar incidental structures to be in the yard setback in any district, but not closer than 3 feet to a property line. The proposal submitted by the applicant is that the fence will be 10 feet from the property line. The 4.5 safety fence is an accessory structure. It is therefore an incidental structure allowed in special circumstances. It is an accessory structure allowed under 185-51. Again, the code doesn't give a lot of guidance on what the standard for a special exception, but it does indicate that it should not adversely affect the adjacent neighboring property. Before we get into testimony from the applicant, I would ask that that you take note of the fact that the neighbor at 103 Carolina has submitted a statement that they do not oppose this special exception. Okay, so that is the person who just recently purchased the property, and they do not oppose the special exception, and they are in fact the person most impacted. If you take a look at the survey that was submitted in connection with the application, you'll note that 103 Carolina is to the west of the property, and that's the owner that has said that they do not object to the special exception. To the west is King Charles Street, so there is no neighbor. To the east, to the north is another home, which is 1702 King Charles, and then directly to the south is the 50-foot right-of-way for Carolina Avenue. So I don't have anything else to add at this point, other than to call the applicant when the board is ready.
All right, thank you. Mr. Townsend, 3 minutes?
Thank you. So it's not typical for the town, as you may know or recall from prior experience, to take a position adverse to an applicant for a variance. And I think the same applies for a special exception. Now, we don't have much experience with requests for special exceptions, but there have been some related to parking and whatnot. And I think the town views them the same way, that it's up to the board to exercise its judgment in this case, and not up to the town to advocate for or against the grant of a variance or special exception. In this case, the nature of the special exception request, I think, though, requires you to conclude that a swimming pool safety fence is in fact a similar incidental structure to a pergola, gazebo, or swimming pool auxiliary buildings. I'm not here to argue what you should conclude, but I think that's an element of this that you need to address. So in subsection C of 18567, it identifies the matters in which you may consider appropriate for a special yard exception, and I think you'll need to either conclude that the safety fence is some kind of an incidental structure that's contemplated by that section, or it isn't, which will instruct you as to how to proceed. You're often asked, some of the more difficult questions asked of applicants for variances is what is your exceptional practical difficulty? That element is not required here. So you may hear testimony to that effect from the public, and you need to weigh that accordingly, because that is not an element of a special exception. And then I can offer up the town manager for any questions that you have, I guess either now or during the course of the hearing, but we don't have any other remarks to offer at this point.
All right, thank you, Mr. Townsend. I believe the burden is on the applicant in this case, and so it's your case to make, and Ms. Faust.
Thank you, Mr. Borson. And for the reasons that we articulated in our submission, our legal submission, we believe that this is an accessory structure allowed under the accessory structures of the code, and is therefore incidental as an incidental structure that is permitted under 18567C. So do you want me to proceed with the questioning?
Yes.
Okay, thank you. Are you, Madam Chair, is that okay?
Yes,
Thank you. Is it
That's
okay
fine.
if she
If you
sits
wanna
here? Thank
stay
you.
there.
Thank you. Okay. Marcia, we have your plan, or Ms. Scheck, we have your plan before the board that you were requesting your special exception for your 4.5-foot safety fence. Can you just explain a little bit what you're doing and what that plan shows?
So, the plan shows 3 feet from the house to the pool area, 3 feet walkway required around the pool. We're not infringing on any green space elements. The walkway around the front that goes into the required front yard is grass. That whole side will be grass. All the elements over there will be grass. The fence will be located 10 feet from the front property line. That's the pink line. The 3 parking spaces are the green spaces, and you can see that one of them is perpendicular to the front of the pool. So you probably won't even see that part of the fence or the pool. The fence, like the property at 114 Chesapeake, will have a nice green hedge in front of it, so you won't be able to see through it, and all the safety features, of course. I think just one thing I want to point out, because people have been saying that previous code didn't permit a pool in the front yard because of the newly enacted September 2024 green space ordinance, but that's actually not correct. Right now, this diagram right here, my green space, when you add up my building envelope, my bump out on the east side, my 10 by 18 driveways times 3.
Why don't we get the submissions?
Oh, submit it, yeah. So I just want to go to the fact that currently this rendition has a total green space of 1,950 square feet. The town requires 1,250 square feet. So I have an excess of 690 square feet in green space. So I made sure we're not violating, it was not the intent here to, I know it's the town's projection, but when I planned this layout, I talked to my neighbors, I talked to my surrounding neighbors. They did not want the pool in the backyard. The house behind me is 2 Kings Highway, so I faced the whole house. So that house would have had no benefit of a clear backyard. It literally butts up to my backyard. When my neighbors came in and bought 103 before Mr. Becker, who just bought, they fully supported this rendition because of the same thing, noise surrounding all the houses and bouncing off. And I think they submitted 3 letters to you all in support of the front yard pool. That was discussed with them before we did it. But I think what I want everyone to understand is in planning something like this, you do pre-construction meetings with the town to make sure the elements of your layout are what they expect them to be. And I don't want to say the word approve. Pre-construction meetings are to say, this is my layout. Are there any objections? So before we go into the final expensive phase of planning, engineering, soil tests, basement tests, we stake out the property line, you get engineers involved. The town says, yes, the site plan is what we're comfortable with. And so what I want to emphasize is those pre-construction meetings were held in August, September, and October with the town in the office, with Evergreen, the builder. This is the exact site plan we presented. There were no objections whatsoever to the placement of the pool or the fence at that time. And it was critical for me because if there was any issue, it had to be determined then. Because once you start the true engineering drawings, now you're getting into $50,000, $100,000, $150,000 before you even start construction. So this was the result of 3 meetings, 2 or 3 meetings at Town Hall with Mr. Dedes and a approval of, we are fine with this. I want to say there was one thing they asked me to do. You see where it says shower? They asked me to remove the shower from the side of the building and allow 3 inches so that it wasn't attached to the building. So when you're looking at this plan, this is what they stamped as, we accept this in its locations if you remove the shower. We of course removed the shower.
Ms. Johnson, if I could,
Yes.
this is testimony, I think, that relates to whether there is some harm that is coming to the client, to the applicant. And we've gone over the standards. I think everybody agrees that that's not an element of this proceeding. The question is whether the proposal is harmful to the neighbors and not the question of what exceptional practical difficulty it imposes upon the applicant if the special exception is denied. And we heard a lot of testimony about what happened and how this permit wasn't granted and how the applicant was told they've got to separate these 2 aspects of the total build because they can't approve the pool. And now we're getting more testimony on this. And I think it was contradicted in part by Mr. Dede's testimony. He doesn't need to be here today because this is a special exception request, not an appeal. So I would just ask you to have limited patience for this type of evidence at this point.
Thank you, Mr. Townsend.
Mr. Townsend, I'm sorry. My point is being that this was long planned, and my understanding of the pole fence provision and poles being permitted in the front yard was clear to me. It wasn't that it was ambiguous. I wasn't going to design an expensive house to have to be here to fight over 12 inches of a fence. That makes no financial sense whatsoever. You would design the house to something you know is clear with the code, and you're correct. I do know the code. I probably know the code better than anyone. And my reliance was on that pools until April of this year were permitted in front yards. So were pool fences.
Okay, all right.
We had testimony.
Fred, she's done,
But,
okay?
no, we're talking about different things here. And she's recharacterizing the events that were testified to
Well,
previously. There was a letter on December the 5th, written by Ms. Scheck's attorney, complaining about the town's position, about the legality of that fence. Why did that letter get written in December of 2025 if the fence was permitted in April or in any time in 2026? Let's
Well, I do,
Stick to
Mr.
the-
Townsend, if I could respectfully
No,
say,
look, I'm ruling you both out of order at this point. Mr. Townsend is correct. The issue now before the board as to whether to grant this special exception or not is whether the exception, in order to grant it, because it's worded in the negative, will not substantially affect adversely the uses of adjacent and neighboring property. So, I mean, it's entirely irrelevant what meetings you had with the town and who said what to whom. None of that matters. The only question is whether this fence additional height will not substantially affect adversely the uses of adjacent and neighboring property. So if we
if I-
can limit it to that,
If I could add, just that it's an incidental structure within the meaning of the subsection, which the town does not take a position on.
correct. Okay, so,
So,
Thank you.
the one thing that she would like to submit, if we may, as an exhibit to this, is she did the green space calculation, so I think it's important to know, to note that this does comply with the green space, the property does comply with the green space. So we would ask that this be exhibit 1. So this is based on this plan. So the next issue is, Marcia, I believe that you have another exhibit that you would like to introduce. Can you pull out the pictures that reflects where, some pictures that show where the fence would be located on the actual site?
okay. Do you want me to explain it?
Hold on, let's get those out. And we'd like to submit an exhibit 2, so you can actually see the site. And you can see where the fence will be located on the site in relation to the neighbors and the project itself. So hopefully this will give you a good visual.
thank you.
So Marcia, you can, you want to go ahead and explain the pictures that you have?
Yep, so the pictures you have, the pole I'm holding is just an indication of where the fence will be on the site. I think there were some concerns about line of sight or safety issues, but I wanted to just point out that you can clearly see my fence is almost 20-some feet, 22 feet back from the street, and also that King Charles all the way down the avenue is sort of inundated with 15, 20-foot high green shrubbery that my fence far exceeds beyond that. And it does far exceed beyond what the code requires for line of sight in those areas. But there is no line of sight issue from where the fence is located.
All right, just so the record is clear, you've handed us 3 photos. I'm going to suggest we mark the first, then separate, we'll give them separate numbers. So the first photo, which we will mark as special exception exhibit number 2, is the picture from the street showing you standing in the middle of the yard. So we'll make this one special exception. That'll be Exhibit 2. The next one we'll mark as Exhibit 3 will be a picture of you standing next to the post. Be number 3. And then the last one will be the one with you. It looks like you're reading a note almost or something in your hand, but it looks, I guess you're just pointing at the post again, and this is the one where you're the tallest or closest to you. And that'll be special exception 104 in terms of exhibit numbers.
Thank you.
Just for the record, so it's clear in case we have to get there.
All right, so
Yes.
Marcia, what did you want to talk about? Just talk about what Exhibit 2 is showing.
Yeah, so Exhibit 2 is showing from the corner of King Charles, turning on to Carolina. I'm about 25 feet back from the street. There's quite a big easement, almost 12 feet, and then I'm 10 feet back. And from the edge of the highway to my property line is about 37 feet. So I'm far beyond where there would be any safety or line of sight issues. And I just want to be able to show you from the site itself.
And I want to also ask on Exhibit 2, there's some shrubbery there to the right of you. Is that along,
That's on town property.
and where is that, what does that front on?
That front's on King Charles Highway.
So that shrubbery is all the way down King Charles
It is,
Avenue?
pretty much for 7 blocks.
Okay. And let's what did you want the board to see in Exhibit 3?
I think Exhibit 3, just the same thing. That, you're looking at the end of the property, then you have an easement, then you have the thing. But I wanted to show you also that that is the easement, the town property or the county property, whatever it is, that we really don't have any line of sight issues in any direction there. And that's where the fence would be, and then the pool, the fence is 10 feet in on the property line, and then the pool is located another 8 feet back from the fence within the buildable footprint.
And do you know how far your property line is from the actual paved street?
My property, well, the street easement is about 50 feet. So from the middle to my property line is 25 feet. And then you have my 10-foot back, so that's 35 feet. And then my pool is located at another 8 feet, so 38 feet.
All right. All right, so the next,
Do you want to go to this one?
sure. So again, we would just ask before we continue that the board take note, and it is an exhibit, the submission of Justin Becker. We actually had it as exhibit, that we're gonna introduce it as an exhibit, but it already should be part of your record.
I'm sorry, what are you referring to?
The email of Justin Becker to the town, he is the resident of 103 Carolina. He has noted that he does not object to the special exception, so he is her next door neighbor.
And was that included in your earlier submission? you said?
We were going to submit it, but my understanding is that was submitted directly to the town, so it should already be part of the record.
That's correct, we have that email.
I don't have a copy of it in front of me.
Here, I can give it to you.
Thank you.
So I don't know if we should make that our exhibit 4, just to be
Yeah,
clear.
number 5. I'm gonna
Number
mark it
5.
exhibit 5.
All right. All right, thank you. All right, so the next thing I want to talk about, Ms. Scheck, is why you chose to locate and why the pool is located, and the history behind the pool being located in the front yard.
Okay, yes, I think I touched on that a little more. I had spoken with my previous neighbor at 103 that just sold the house, lived there about a year and a half. And they were very supportive of the pool being in the front yard. They did not want it in the backyard. They felt the noise would ricochet off all the houses. And they felt that the noise or pool chatter, whatever, it goes out to the, what do we have, about a 50-foot street front? And it is how I contemplate pools, quite frankly. It's a lot better to have a straight front pool set back. It's in my buildable footprint. It's where I can fully build a house or any other thing in there. And the only issue being the fence. I found that most people I've talked to wanted it not ricocheting off of 5 houses behind them at 12 feet distances from each other. So both my previous neighbor, which I think you have submissions from when they were there, and Mr. Becker both supported in the front. And that's the logic. It's also logical in terms of how a house is planted on the lot. I like pools to be in an area where they're open to the communal living, the porch, especially for a rental or a family. The kids can be monitored, that they're not tucked back in the back of the yard where you have to go through a hallway and out by the back door to see who's in the pool. This makes everything central for safety, to where people are monitoring the activities. It's very clear in terms of being able to, your front porch, your living area is right there where your pool's located. So I think that's a really reasonable assumption of how and why I locate pools where they are.
Ms. Scheck, before you move on, I just want to make sure my notes are correct. You said you talked with neighbors, but it was not Mr. Becker. So who was it that you spoke to who said they didn't want the pool in the backyard?
So the Winstons, who you've had, I think, 3 letters from,
And which property do they own? Or
103 before Mr. Becker,
Oh, okay. So they don't own the property now?
they don't own it now.
Okay.
And for the record, they sold that to the Justin Becker, which is the exhibit I just gave you, Mr. Forson.
Right, okay.
Did you?
And I did talk to the neighbor in the back, though I don't have his name with me. We talked on the phone, and
And
I,
that would be 702 King Charles.
King Charles,
All right.
when I was explaining, I called him and heard he had some concerns about my construction. I wanted to just introduce myself and make sure I gave him any information he needed. And I told him why I logically did the pool, and he, said he was glad it wasn't facing his house.
And did you see the submission that you
I
made?
did.
And what's your reaction to that
I was a
submission?
little
And
surprised
why were you surprised?
because he told me he was happy I didn't put the pool in the backyard facing his house. We're only 12 feet apart in the back.
So if you had put the pool in the backyard, how close what would your
The
setback
pool
been?
would have been 6 feet from his back property line, and because his house sits sideways, he only has 8 feet, so that would have been the distance to his house.
So you would have had
And-
8 feet
and
to
it-
his house, and how far would your pool have been back? from
6
his?
feet from my house, 8 feet from his house.
So there would have been a 14-foot between
Pretty
the pool and
much.
his house.
And I think that's what my neighbors both at 103 were concerned about too. 103 is pushed all the way to the back of the lot to 12 feet, and they were concerned about the same issue, and that's why they preferred it in the front.
So let's talk a little bit about, looking at this plan, let's talk a little bit about people that are across the street from you.
Mhm.
Okay,
Ms.
so,
Faust, before you do you want to maybe either move the tripod forward so the board can see it?
there we go. Let me get, where's the?
I'm okay, I can see this one.
Yeah, let's see, let's use this one, it's a little better. Oh, it's not nice and highlighted, but I'm gonna.
No, it's not highlighted.
I'm gonna put this as a backing, let's do that.
Do you want some tape
Oh,
for it?
there's this one here too.
Yeah, we got it. We got it. So I'm gonna hold that. So Marcia, you might need to come up here and start. Just good. Okay, so we're gonna do old school. So, Marcia, I just wanna talk about, so this is Carolina Street, correct? And the width of Carolina Street? 50 feet. 50 feet. All right, so your pool is 18 feet back.
This is the easement, so this is where you have all parking for public.
So this is a street, this is the grassy area between your property line, this is your property line, right?
Mhm.
Okay, so the fence is pink,
This is
and that's 10 feet from your property line.
12 foot, 12.5 from King Charles.
Okay, and it is, what, 10 feet from your property line? And then the pool is 18 feet from the property line. All right.
18.6.
Okay, so people that are across the street, let's tally the difference, how far that pool is from people that are across the street. So we've got,
So you've got 18 feet here, you've got 50 feet here, and then you have an 18-foot setback to the next house, so it's about 86 feet.
so the closest house across the street is 86 feet from her pool. As opposed to 12 feet if she had it in the backyard,
It's a problem.
and how far to the side? 8 feet on the side.
And that's why my next door neighbor did not want it in the back.
When the house be moved forward, you said it would be closer in the back, but when your house be
So
moved forward.
I could move the house forward, but in the back, the pool, because you have a deep front setback
Mhm.
and not a deep back, the pool would only be located 6 feet from the backyard.
Couldn't you have a smaller pool?
That's the thing. Well, that's a prerogative, but the law says I can have it 6 feet, and most people have it 6 feet.
I'm just asking the question.
Yeah,
Yeah,
yeah, I mean,
okay, I was just curious.
Yeah.
We're
yeah,
giving more
it's
room in
6
the
in the
back.
back.
Okay.
So. This is so really. Thank you.
I think that, if I could say, I think the other important thing.
I want to make sure your voice is getting.
Okay, yeah. If I could say, I think the other important thing I just want to share, as you see in the pictures, there's very little difference between a visual sight of a 3.5-foot fence or a 4.5-foot fence. If you want to,
Yeah, so-
please.
We want to submit this as an exhibit. And this will be exhibit 6. So you can just tell them what this is.
Sure. So, this is the two renditions. This is a 3.5. This is a 4.5. This is my house. This is what it's gonna look like. I did this as close to real as I could. The car in the front will be its permitted parking space there. I take a lot of great thought to landscape my lots after I do it. So we are gonna have a full hedge fence that's gonna go up in front of this so that it's a barrier. 114, you don't even know there's a pool back there. And, we will quite nicely landscape. I just had a conversation with Mr. Becker today. We're gonna work together with what he would like on the sides so that he can have as much privacy. I also told him I would work with him on any noise deafening adjustments I could make to help him because, I live down the block. I've lived here for 20 years. My intention in any of my rental properties is to make sure I listen to my neighbors and we provide, supervision, guidance, everything we can. So Mr. Becker and I are going to work together on the side so that we can do as much as possible between our properties. And I'm sure more than what the town requires me to do. It's okay with me. That's okay. We want to be good neighbors. So this is pretty much what the design will look like. And Mr. Becker and I will work together on his side lot.
Can I ask a question about that rendition?
Mm-hmm.
I'm just having a hard time orienting that with the sketch, because it looks like there is a road on the left side. Is that from the Carolina?
This is just, you hire a landscape artist to do these. They can get as close as they can get. Parking, I have 2 parking spaces here, so if you just visualize on your sketch, it's 2 parking spaces. So he'll have the parking spaces there, and then we'll build a perimeter of, we can do a privacy fence up to 7 feet on that side because we are in the buildable footprint. And I assume that's probably what he'll want, and I'm amenable to that. And then this side, of course, goes to the property line, and this would be pretty visual of what's on King Charles Street on my side. This is a really good rendition. I asked the architect to please make it visual to the scale so that this was 10 feet, and then this was at 4.5, and this was at 3.5. So we were,
Your boundary line then is right up against the bushes in front of the car.
My boundary line has a foot, yeah, it's about a foot.
So beyond that green area in front of that is right away.
So this is right away, and this would be public parking, so there will generally be cars parked here anyway. Mhm. And, yeah, that's pretty much the visual.
Do you have a 8.5 by 11 of this at all, or is that the only copy we have?
We do that we could submit after the fact, probably. But that's the only copy. We don't have that with us.
Well, if you can just get a copy to the town and to me.
Yeah,
So again, we have a complete set. We'll obviously hold on to that
yeah.
in the meantime.
If you could hold on to that, we'll get you, can you get that over tomorrow?
And the porch is the positioning of the house, so the whole living area is in the front, the porch, the pool, so everything is communal to the front. All the safety, we probably exceed safety mechanisms in terms of what we put on our fences, water devices. I mean, we really want to make sure, whether it's my family or another family, they're safe.
So Marcia, let me ask you a question. Was there another reason that you did not want to put the pool in the front yard that you haven't articulated?
In the front yard?
I'm sorry, in the rear yard that you have not
Well,
articulated?
yeah, I mean, look, we try to save as many trees as we can. I'm a big advocate of saving the trees. When we designed the plan, there was one tree in the back we had to take out no matter what, because it was in the building footprint. There is a giant loblolly in the back that we did not want to take out. There were 2 or 3 in the front we had to take out because they were in the building footprint. But we will actually exceed the town's requirement. I always do for trees. We will put back more trees than required. And I would rather pay for larger, more mature trees so that we get the canopy back. But even in the front, I think Bill would confirm this, I had asked the town if I could move my driveway 1 foot to save one of the loblollies. And they said they did not have any leverage to give me, I would have to go for a variance for that. And we had to move forward. So we really do, all my properties on Jersey that I built, I think I took out 2 or 3 trees, and each one of them I replaced with 10 to 12 trees on those properties. I just
So,
like to talk about this stuff too.
do you have anything else that you want to add to that?
Do you have any questions?
So, I want to ask you about these other matters. So, I want to talk about why you do not feel this will be detrimental to the neighbors. And if you have any things that you want the board to see to explain why you don't think it will be detrimental to the neighbors.
Sure. Well, I think as you can see, the house, I hope you feel is in the character of the neighborhood. The house is about, I believe, 3,000 square feet, 2,900. I had, code would allow me to build to 4,000 square feet. So I could have built a lot more house than this if I wanted to. I think one of the things I hope you'll consider in looking at the character of the neighborhood is, can I submit this one first? This is the first one. So what I tried to pull out in
I'd like
this
this to be exhibit 6.
small report
Exhibit 7, pardon me, I can't do that.
is these are current examples of fences that were permitted to exceed 3.5 feet recently. I know there's a lot of talk about grandfathering. If you don't mind, I'll come back here so I can see you. There's a lot of talk about grandfathering. On this exhibit, I just wanted to show you recent construction or new construction within the last 2 years where the town is actually permitted, or I don't know, maybe without their knowledge, fences in the front required yard, many almost to the front lot line that exceed 3.5 feet. So on the first one, I want to note the first page, 112 Jersey Street. This is my house. I built this house it was completed in 2024. It has a permissible 5-foot encroachment into the front yard setback, that it sits at 34 inches high. When you exceed 30 inches, the county requires a 3-foot minimum safety fence. So that encroachment into the front yard, required yard, is 5.5 feet high. So that is if we are saying that we don't allow anything over the 3.5 feet, we absolutely do by code allow over 3.5 feet. Ironically, my permit for this rail on this extension was given in January 2026. The same month my permit was denied for my 4.5-foot fence in the same required front yard at 101 Carolina.
Marcia, we're gonna.
No, this is not a precedent-setting board, so we're
Okay.
not looking at anything that's happened.
So
in the
we
past.
can just look at the next one is West Street. That's I think the measurement, it's a 5'6" fence in the front yard.
Okay, again, Ms. Schreck, this is not a precedent-setting board. We're not looking about what's happened in the past. This
I'm-
can go on a case-by-case basis. and
Correct.
Those cases don't apply to this case.
I think what I'm trying to make applicable is the character of the town and how this wouldn't be different from what's already in the
These
town.
are railings, not fences, that you're.
No, these are fences. 105 Dover is a fence. Then you have 106 Reed is a fence. That's 4 feet on the front property line. Most of these are fences. You have 1 Collins Street, 4.5 fence.
Okay, but some of these properties aren't in the area of Chesapeake, or not Chesapeake, but Carolina.
Actually,
We're
it's
talking
mo-
about Collins, or talking about, there's.
Collin is in the same district. West is in the same district. These are all NR district.
We're talking about Collins on the south end of.
No, these are NR. The only ones that aren't are Dover and Reed. But it really is not applicable because we're talking about the character of the community. The 3.5 fence limit is for the entire community. So I think the other report I'd just like to enter in was the one that David Moskowitz talked about. I think that speaks far more largely to how this would not be intrusive to the character of the town. And I think my point with this is not precedent setting. It really is about what already exists in the town. So this
This
I
would
did in early
be number
April,
8.
and I submitted it to the planning and zoning board at that time. This is only NR. This is only the streets within 3 blocks of Carolina. And so in terms of how will my 4.5-foot fence, 10 feet off the property line, fit with the character of the town, there are 100 or 101 exhibits showing structures, hedges, fences, or walls exceeding 3.5 feet in the NR district from Chesapeake, Carolina, Jersey, west. So all of these pictures would be considered violations of the code, but we don't really pay attention to this in the North End especially. It's very honky-tonk. There's a lot of 5-foot fences on the property line. There's a lot of structures exceeding. They're mostly on the property line, not 10 feet back. And a lot of hedges that have been allowed to grow on the property line to 8, 10 feet high. So I think when you look at this and say there's 100 examples within 5 blocks, well, actually, 2, 1 north and 3 south of my particular block, that it's to show you that this does not differ from what the character of the town already is. In fact, I would say my pushing it 10 feet back is, allows for a lot more open space than a lot of these pictures.
Right, and so, look, we're gonna obviously admit this into evidence, but I think the question has been raised as to relevance. I get the argument you're making, but the standard is whether this particular higher fence, 4.5 feet, will not substantially affect adversely the uses of adjacent and neighboring property. So do you think
Okay,
showing us
can I-
evidence from something 2
I
or
will.
3 blocks away, that doesn't necessarily go to this specific one?
So on Carolina,
Share what's going on.
on Carolina, there are, I think, 15 houses that have structures that exceed mine closer to the front.
Were those built recently or are those existing? So, there are different standards for non-conforming properties.
And I think not going to standards, this is going to the character of the town. The character of the town already exists in this sort of honky-tonk situation. A lot of these hedges, yes, they were planted very recently and they've been allowed to grow to 5, 6, 8 feet on the front property line. I don't really think that's relevant in terms of the character of the town. I think the character of the town on the north end is what you see in these pictures. It's a little bit of hodgepodge everything. And I don't think a 4.5 foot versus a 3.5 foot fence 10 feet back will adversely affect any of the neighborhood properties. And I want to remind you, we're not talking about the pool. If I pushed the house to the back and if I had 3 more feet in the back and had 3 feet in the front to put my fence, I could put a 7-foot stockade fence in the front yard on the property line. What I'm trying to do is something, I think, far more aesthetic, far more keeping in what we want the aesthetics to be, but that is not the aesthetics of the town. The aesthetics of the town is what you're seeing. And I do not believe it's going to adversely affect. Certainly my next door neighbor has said, I do not want that stockade fence, I want this. And he's got a fence pretty much where my fence will be at about 4 feet high in the front yard. So I think respectfully, the pictures speak for themselves in terms of adversely affecting the character. And on Carolina Street, there are quite a few. Just looking for Carolina.
Did they say Carolina?
Carolina Street has 9 properties in the first block, 20 in my block, where there are structures over 3.5 feet far closer to the property line than mine.
Is there a page that you could cite them to?
Sure. I just want to get to my second block so you can kind of see that. This is an example of some newly planted hedges on the second block. Well, a lot of these structures, and I want to say, Julie, I'm sorry, I forgot your last name.
Johnson.
Sorry, Brad.
Like, these are the grandfathered fences. This is how the town started. And we don't want to take them away. It's part of the character of the town. We really are a little honky-tonk on the north end. We like it that way. I live on the north end. I've lived there for 20 years. This is how we like it. We really don't want the town coming in and saying, correct these, take them down. We don't want to be an HOA. We want to have a very different feel, and that's what we have up there. I think the other one that I just want to give you a quick example of is, this was a major renovation just a couple years ago. These skip laurel hedge on the property line was part of their construction plan, and they are now about 5.5 feet high. That's 3 doors down the street from me, and those are on the property line. So they were part of a new construction plan. I think it's a little far-reaching to say that looking at all these and understanding the north end, having lived in the north end, this is how we like it up there. We don't want sidewalks. We don't want you to tear down the old fences that are grandfathered. And we want people to replace them with them when they get rotted. That's the whole character of the town. It's a hodgepodge up there. And I would hate to see it change from that, honestly. But I do want to make the point that we're talking about 30 properties within my block that have heights higher than 3.5 feet, many much higher, and most right on the front property line. Any questions?
Do you guys have any questions for Ms. Schick? No. Okay, thank you.
Anything else?
Ms. Faust, do you have any other witnesses?
We have no other witnesses.
Madam Chair, I think at this point it would be appropriate for public comment and also for you to reflect or summarize or just announce we've gotten all those emails already.
Okay, so the emails, some of them have already been mentioned. We did receive which is Exhibit 5, the email from Mr. Becker saying that he's in favor of the plan the way it is. There are 2 emails from the previous owners, the Winstons, basically also, I guess they were spoken to prior to the plans being started. They also were in favor of the project. Obviously, they're not gonna be the ones living there anymore. But they were in favor through the planning process of the plans the way they are. I've got an email from the adjacent owner at 1702 to King Charles, which is the property next to
It's behind.
or behind. Yeah. And he is not in favor of it. He believes that if the pool had been in the back, it would have actually been better for him because of the way the building plans are now, HVAC systems and other things are actually closer to his property line than a pool would have likely been. That's, I'm summarizing, but that's essentially his, I've got an email that is, is written by Faye Paget, Jeff and Karen Lang, Jamie and Aaron Slotkin, and Lee Greenfield, who live at 106, 102, 107, and 108 Carolina Street respectively. They also object to having the pool safety fence being approved. I'm just skimming really to see if there's anything else that's.
Which one is there?
So basically they apparently watched the last meeting, they cited the precedent of the pool fence at 114, that was approved after the fact. They feel that it's asking for forgiveness, not permission, is the gist of that. Another email from the Pattersons on 106 Chicago, that also are against the variance. It's actually not a variance, it's an exception. I think most people cite a variance because there's not a, most people are used to variances in this town. Basically, their point ultimately is that they would have liked to have added a swimming pool, but they didn't want to sacrifice living space for their home. They wanted to be compliant with the building codes, and they don't feel that there's a hardship with this. And again, that's not the standard, but that is the gist of that email. Diane Hansen, former commissioner, basically also indicated that the pool can be located elsewhere than the front yard, and it's a personal preference for where a swimming pool can be. I've got this email from, signed by 38 residents that is that they are against the exception.
No, it's not.
Again, some of these things don't apply, but their bullet points are stated the hardship is not valid. The setback exists to present this kind of encroachment. They also mentioned the precedent of 114, it's misleading. Front yard placement introduces noise to both the front and rear of surrounding homes. The parking concerns remain unresolved. That is beyond our purview. And that was signed by Cindy Souza, 113 West Street, Edwin and Sandra Schoenfeld, 19 Jersey, Ray and Donna Alexander, 211 Carolina, Paul and Diane Palmieri, 20 Jersey Street, Daryl Helms, 21 Carolina, Martha Morrison, 111 West, Sarah Anders and Eric Nelson, 11 Jersey, Barbara Harkaway and Beth Harkaway, 106 Jersey, Grace Corradino, 205 Carolina, Mark Lukowski, 21 West, Aaron Yetman, 112 West, Elizabeth Blue, 23 Cullen, Paul Burdette, 117 Jersey, Camille and Bill Samasic, I butchered that, I'm sorry. 16 West, Lisa Levine, 208 Carolina, Elizabeth and Andrew Obrecht, 2 Carolina, Al and Sherry Sissel, 19 West, Christina Hoove and Pierre Roberts, 9 Carolina, Mike and Karen Patterson, 106 Chicago, Rick and Luann Judge, 10 Chesapeake, Bruce and Victoria Carper, 104 West, Joe and Junan and Jen Colagano, 106 West, I'm sorry, I'm butchering some of these names, Karen Sandler and Joe Yodelson, 115 West, Jeff Burkowski, 21 West. Finally, well, not finally,
Which comment, who was that comment from? I don't know that we have that one.
those were sent directly to the town, I don't know,
You were reading names.
yeah, it was on the email,
Who was that email from?
that was from, well, the people that I just read. It's, the email is dated the 30th of April from Cindy Souza.
Okay, thank you. Okay, gotcha.
She also wrote a separate email on just her own behalf, basically writing about, she'd gone back through some online videos of Charter and Code Committee, and the reason for the setback and green space requirements. So she cited to some of the different meetings about the minutes and what occurred at those meetings. I don't know that they're relevant in this case, but she was pointing that out for the board. And that's the last one, because attached to that is her previous email with the names that I did prior to that. So those are the public comments against. I will open it up to public comment for anybody who's online.
Sure, Julie, if it's okay, I'll just go in order
Yep,
on the list that's showing up for me. And just a reminder, we'll give everyone 3 minutes
Yes.
each.
thank you.
Okay,
And
so,
before we do that as well, just for the record, Ms. Scheck had been sworn at our last meeting, and so she was still under oath when she was testifying now. So when people offer comment, and we forgot to do this during we had the person online, but they just need to swear to tell the truth, the whole truth, and nothing but the truth, each person. And that won't count against their 3 minutes.
okay, so first is Christine. Christine, do you want to make comment? You'll need to unmute yourself if you do. I'll move to Danielle. Did you wish to make comment? No comment from Danielle. David, do you wish to make comment? And what about Greg Griffin?
Are we sure we've got connection?
Yeah, something's not right.
Yeah, I don't.
There was a problem with the internet earlier this afternoon. I don't know if it's reoccurring or not, but there was.
Greg, did you want to make comment? I saw you unmuted, but we can't hear you. And Christine, you just said you're available. Did you want to make comment?
Hello, yes, I apologize. Previously, I wasn't available. Yes, I just want to reiterate a letter that I sent earlier today. I apologize, you may not have received it as of yet, but I'm pretty sure you're clear on my stance of not approving the pool in the front and specifically the fencing for safety purposes. I had another question.
Christine, before you go on, for the record, can you state your full name and then tell us that you swear to tell the truth, the whole truth, and nothing but the truth?
Christine Uve, Huve. Yes, I swear to tell the whole truth and nothing but the truth.
Okay, now you have 3 minutes. Thank you.
Okay, so I just mentioned the letter I sent, which bullet points my issues with this project. But I had a quick question. Marcia said that she had 2 parking spaces. How many bedrooms are in this house?
She's got 3 parking spaces.
There's 3 on the side of the house?
Yeah, there's 2 on the side and 1 in the front.
And the front, is that part of the street parking, or is that part of legitimately her property parking?
It's her property parking,
Okay.
based on the plan that we have.
Pardon me?
Based on the plan that we have, it's in the front,
It's in
on
the
her property.
Okay, so there's still street parking in front of the house for neighbors and renters, et cetera?
Correct.
Okay. So one of my biggest concerns, and has been from the beginning, is safety with the higher fence line and that corner area, amongst other things. So that's all I have to say.
And where do you live?
I'm at 9 Carolina Street.
Okay, thank you.
Okay, I want to check back with Greg. Did you want to make comment?
Can you hear me?
Yep, now we can.
Okay, sorry. Hi, my name is Greg Griffin. I live at 1702 King Charles, directly behind the property, and I promise to tell the truth. The first thing I want to state is that earlier the developer stated that we supported the pool in the front yard. At no time did we ever verbally or in writing make that statement, and nor do we. And so the thing that I want to state is that we keep talking about the pool being in the buildable lot, but in my mind, the pool deck and the pool enclosure is really part of the pool. You can't build the pool without the deck. You can't build the deck without the fence. You can't build the pool without the fence. So in reality, the request is for a deck and a fence in the front yard. And my concern is that, if we start losing green space, that will affect our adjacent properties. The developer talked about how green and great the neighborhood is, and that's what we're losing. So they stated that the deck was going to be grass, and my question to the Planning Commission is, if you approve this, how are you going to guarantee us as neighbors that will always remain grass? We look at those front yards for landscaping to set people's houses away from one another. And I do believe that having a fence and an open pool enclosure in the front yard will adversely affect the overall value of the properties in the neighborhood.
Thank you, Mr. Griffin. Now, did I correctly, I know I summarized what you wrote in, but is there anything else that I didn't mention from the email that you wrote to the board?
Well, I believe in owner's property rights, and the developer has every right to build the house within the property. At no point did anybody come to us and say, hey, we're thinking about building a house. Would you mind having a pool behind your house? We would have been much, much, much happier with a 16 or 18-foot set yard and a swimming pool in the backyard and the house set farther away. The air conditioning units are now tight up against their back property line, sitting in that open space, as the developer said. So we're going to hear those 12 months a year, as opposed to, 3 months in the summer, some kids yelling Marco Polo, which is part of why we go to the beach. So, and the most important thing to me is that, this is more than just a fence. It's the deck and the pool. So it's really the pool in total that's requested to go in the front yard. And if you do this, you need to guarantee us somehow that all of a sudden it won't be a 7-foot fence, and all of a sudden it won't be pavers that'll make our surfaces harder and less green space around our house, which does adversely affect our property.
Okay, thank you very much.
Okay, Faye, you're next if you wanted to comment.
I do, excuse me, I do want to comment, and I promise to tell the truth.
And Faye, where do you live?
I live at 106 Carolina.
Thank
which
you.
I have owned for 50 years.
And what is your last name, Faye?
Faye Paget.
Thank you. You're on.
You said the most important consideration in granting this exception is that the neighbors not be adversely affected. And you said adjacent neighbors. Marcia talks about having the agreement of the fellow next door at 101 Carolina. That young man bought the house 1 month or 2 months ago. He has never lived there for any period of time at all. So he does not know what he's getting himself into, nor does he understand the character of the neighborhood. She said she talked to other neighbors. She did not talk to me. And if you will see from the letter that I submitted, there are, if you count the 8 houses that are immediately adjacent to 101, I already discussed 103 where the new young gentleman lives. Of those 8 houses, if you don't count Marcia's house, which would make 7 houses, I submitted a letter from 4 of those 7 people saying that they vehemently object to the fence, the pool, the whole thing. So if your concern is the neighbors, we are the adjacent neighbors and feel that this should not be approved as a variance or an exception.
And Faye, what specifically has you concerned about the pool in the front yard with the fence, the 4.5-foot fence?
Well, from my particular vantage point, the front of my house has a huge screened-in and also windows at when appropriate porch where I spend 70% of my time when I'm at the beach. So any pool in a front yard is going to disturb neighbors with the noise that necessarily occurs there. It's not a lap pool where someone just has 3 or 4 feet of water and they can swim and be quiet. You know, this is a 6-bedroom house that takes up every available buildable area of the lot. And then to have a pool in front of that, to me, it's obvious, and I don't think it will add to the character of our street. In fact, I think it will be greatly diminished. And I guess I also have to say that I object to Marcia calling our neighborhood honky-tonk. It's anything but.
Thank you.
Looks like David does want to make comment.
I'm waiting to be sworn in.
Can you swear him in, please?
Can you state your full name for the record, and do you swear to tell the truth, the whole truth, and nothing but the truth?
David Moskowitz, and yes,
Thank you.
I'm a full-time resident. I live in Dewey Beach. The first point is Cindy Souza's petition. From what I read, it's filled with some truths and some half-truths and some false statements. Never before has the town, like you're asking people to swear truth, so you have Christine and Faye on the phone, and you're taking my testimony. She just put names on a petition. There was no like, sort of like on the web, you have to actually vouch who you are. There was no vouching. She just put names on the petitions. Who knows if they even signed it? Like there was no signatures. So I think the board would be best to dismiss it. That's the first point.
Mr. Moskowitz, can we please stick to the issue at hand? How you feel about other people's
Well, that is
comments?
yes, but that is the issue because you're weighing evidence of people and you're weighing people who actually calling in and swearing to tell the truth versus a petition of names who did not show in and swear in. So that's important because why else am I swearing to tell the truth and other people are not? Second is I believe that Marcia should be granted the exception because I believe the town targeted her. I believe it's not inconsistent with the neighborhood. In my property, we have a pool in the front yard of houses, and it's not what people describe. It's a place of families and kids. And I believe Marcia should be granted it. If you look around the north end, if you look around Dewey, what she's looking to do is just literally put a fence, and I think it was misdescribed earlier as 1.5 feet. It's actually only 1 foot. She's just looking to put a 4.5 fence. The pool's not the issue, the fence is. And she's just looking to put a 4.5 fence. I don't think it's a big issue. My third point is the amount of money the town already spent. They already spent about 20 or 30,000 on this. This is probably going to go based on the history to federal court, and it's going to be like 100,000. It's at this point where the town should allow Marcia to. We're talking 1 foot of a fence. Let her do the fence and move on because honestly, my property's been around since 1982. They have a pool fence abutting Route 1. There's been no issues, no noise. Like all these people are talking about the pool, but the issue is the pool fence. And I would like Marcia to be granted this exception and then reiterate people who are being sworn in to tell the truth should be given weight versus emails, I don't know if the board should consider. My final point is, from what I did from a FOIA, it appears most of the board has not taken the required Board of Adjustment education. So that's a point which is of concern. I would hope that in the future, the board would consider taking it, because Marcia is supposed to be going under a neutral board, and I don't know if it's neutral because they're not educated. You have a town solicitor, and the town has never targeted someone like this before with all these briefs and stuff, and
Mr.
it's just
Moskowitz,
wrong.
You're at your 3 minutes. Thank you.
That's it.
That's it? Okay.
All right, is there anybody here? It doesn't appear to be.
The two folks that we had seem to have gone away. Yes?
Okay, at this point, did you want to offer any?
Yeah, I think she wants to rebut a couple of things with regard to the public comments, if we could, please, and we'll be very brief. So I think the first thing we want to do is, with respect to the Cindy Sousa email, Marcia, and you have read the names on the Cindy Sousa email, and I think you wanted to offer some comments about that.
Well, I just want to keep with the consistency of you all asking me how it would affect my street. And I think on her email, there were 4 people on my street that were listed on that email. I think the other thing, in fairness, I want to say was one of the first emails I got, there were 2 people I called that I knew, and they said they never gave permission to be on the email. So I do think it's important in terms of valuing that. But I also want to say I just looked at my call record, and Faye called me right after the last hearing, and we had a 27-minute conversation. I was very concerned about her being on the last hearing, not being able to speak. I reached out to her, told her I wanted to understand her concerns, and she called me back and we talked for 27 minutes. So I just don't want people to think that we're up here making things up. I do want to remind everybody, though, that we are not talking about the pool. When you read a lot about the objections, it's you shouldn't let her have a pool. We don't want a pool. It's really about the 1 foot of fence and the location of the fence. And I hope that my exhibits have shown, without testimony, with all of these other names and fighting, I don't think it's healthy in Dewey to do this. It's not. It's wearing, it pents neighbors against neighbors, and then we have to try to fix everything. And I just want you to redirect everything to this is about the fence. And despite the fact that a lot of people are talking about the pull and pull noise, it's about 1 foot of fence. And I feel that my submissions have certainly clarified that it's not out of character with the town. And what you want to think about is the placement of my fence at 4.5 feet going to cause harm or disruption to other neighbors? That's really the question. And I think it's easy to get off focus with that. Like I said, I could put a stockade fence 7 feet high, and that will certainly not be what I want. And it's certainly not within the character of the town. But this is really about, will my fence at that height, placed where it is, cause character disruption or disruption to the neighbors in any way? And I can't, it's hard for me to come up with a reason why it would. And I hope you'll explore that while you deliberate.
Well, I guess the reason I think most people have a hard time separating the pool from the fence is that you wouldn't need the fence if you didn't have a pool. And I think that's where.
Right, but we'll have a
some people choose
fence.
together.
Will it be 7 feet high and a little further back?
It can't be, because you're in the setback, so it can't be 7 foot high.
Well,
Unless you took it back to the property line.
correct.
Which from every indication, you haven't been willing to extend it back to the fence back to the property line.
That's correct.
So I guess that's where I think people they automatically connect the two.
But I do want resolve that that is not the issue in this. That's not what we asked
Right.
for. Thank you.
Okay, so I'm gonna officially.
Do you have anything else to present, Ms. Faust?
And
Do you want to offer any very short summation?
I think,
May I comment real quick in case she wants to touch on it?
Mr. Townsend?
I don't think that it's, I don't think that the board needs to hear a lot on this point, but there's a lot of evidence here in terms of this document reflecting alleged non-compliance with the code and targeting, if you will, is the kind of the implication. But the town's silence shouldn't be interpreted as an acknowledgement that the town approves bushes that get planted and then end up, not every bush is a hedge, not every structure that exists in the 12-foot setback or in the 18-foot setback, depending on where you are, is illegal if it was constructed before the setback was imposed. So I don't want to take the town's, or I don't want to take the board's time. You wouldn't tolerate it going through all this. We weren't prepared for it. But I think you would find that a number of these circumstances exist legally, although they might be non-compliant. And I concede that it is perhaps relevant to bring this kind of thing to your attention, because it feeds into the argument as to the extent to which the public is harmed. So that I will concede, but I won't concede that we're allowing numerous non-compliant structures to be placed in the setback for other people and not for the setback.
I think your comments are well made, and I will say I thought it a bit offensive for someone to be suggesting there was targeting going on here. But having said that, the only issue before the board, as I said at the outset, is whether granting this exception or not. And the code, again, it's very oddly phrased, will not substantially affect adversely the uses of adjacent and neighboring property. That's the issue. It's the only issue. And so, Ms. Faust, did you have a short summation for us?
I'm going to officially close the public meeting, but I do want to hear from both sides as far as if any summation wants to be, and then we'll ask questions, the board will ask questions after they, we'll ask questions after they conclude. Does that answer your question?
I think that the board gets the issue. I think that Marcia would like to say one thing in response to Fred's comment. So if you want to go ahead.
Yeah, Fred, respectfully, I understand what you're saying. And I know we both got off track at the beginning and then Mr. Forson reeled us in. But this is not meaning, and violation, as I said in the credentials, it's meant to be indicative of the characteristics of the town. And so I apologize if you took it that way. It's really just about, is my fence in the characteristics of the town? And I would just suggest for the record, that's how we review this, for characteristics.
All right, so with that, I think Ms. Faust is not going to say anything further, and we turn to you. If you have questions for anybody, ask your questions. And when you're done asking questions, then we'll deliberate.
I have a question. I just want to be clear on what we were voting on here. Is it the position of the fence and the setback, or it's just the height of the fence exceeding 3.5 feet?
It's the height because it's in the setback, and according to the code.
A fence could be as high as 3.5 feet. If I said 3 feet earlier, that was just a slip of the tongue. You could have a fence 3.5 feet in that setback area, and it would be permitted. But because we want to make it, they want to make it higher, 4.5 feet, they have asked for a special exception to do a fence that's 4.5 feet rather than 3.5 feet.
Because it's required.
That's required to have.
And it's, I know that, I realize that. So, but by accepting that, giving them their variance here on the 4.5 feet, does that let the pool in too?
Correct.
They would not be able to have the pool without the special exception, correct?
Not this pool.
Not this pool, not as designed.
Not as, yeah.
Right, I mean, if they made the pool skinnier, and brought the fence back to 20 feet, then I think they could. But again, the question isn't, the only question for special exceptions is whether this request will not substantially affect adversely the uses of adjacent and neighboring property. And that's different, as I think we said at the outset, from what you're normally used to doing when you're granting variances.
Do you have any questions, Dave?
I don't really know. The one thing about the public comment is that they probably weren't familiar with this legal standard for an exception. So we didn't really hear people specifically talking about their uses, except for the one woman who talked about using her porch and so forth. So,
And the man, Mr. Griffin.
right, the one in behind on King Charles. So that's, but I mean, it's clear from the public comment that there are people all over the neighborhood that say that it will affect their use. I'm not sure they're really getting to that issue, yeah.
Well, I don't think they're saying it's affecting their use personally, they're just against it. And again, they were using more language of variances
Right.
than the special exception language. Because I don't think, even as a board, I can't remember the last time we saw a special exception versus a variance request. So it's a little bit novel for us as well, which is why I wanted to make sure before we got started that we knew what the standard was. Mr. Forster, can you read again the second part of that about the auxiliary building? Because I'm kind of hung up on the auxiliary building language.
I think the request is appropriate, but let me read you that again, you're right. Special yard exceptions may be granted by the Board of Adjustment to allow, in special circumstances, the installation of pergolas, gazebos, swimming pool auxiliary buildings, and similar incidental structures in the yard setback area in any district, but not closer than 3 feet to a property line. And I tried to emphasize the phrase similar incidental structures because structures is defined to include fences.
Okay, and that's where I was going with that. Okay,
Yes.
thank you. That clears things up, because that's where I was, the listing of gazebos and pergolas and all that stuff had me. I want to make sure I'm not overreaching or.
And the special circumstances have any, is that a term of art?
I think that's up for you all to decide.
Ah.
I mean, but really, as I say, as I read the code, you can make a request, and if you can demonstrate that your request will not substantially affect adversely the uses of adjacent and neighboring property, then I think, at least from my property rights point of view, I think you're entitled to that special exception, but you've got to satisfy that test, and it's up to you all to decide whether or not this 4.5-foot proposed fence will substantially or will not substantially affect adversely the uses of adjacent and neighboring property.
And in this instance, can we take account of the March legislation or ordinance that is specifically goes to this point?
The March legislation doesn't affect the special exception request. The March legislation clears up the ambiguity that was involved in the legal dispute we had earlier. So even if that legislation, had been in place before Ms. Scheck had made her application, she could always request a special exception. Just like if it didn't qualify for a special exception, she could always request a variance. But that code amendment doesn't apply to this discussion.
Except to the extent that it shows the clear intent of the town.
Well, the town has said ordinarily you can't do it, but it left the special exception language in place.
So you
see
can
what you're
still,
saying.
she can
Got it.
still
Yeah.
ask for that.
Okay.
So, any thoughts? Anyone want to go first? What your thoughts are? I'll start with you.
Well, it is very hard for me to separate that a 4.5-foot fence is required to have a pool. And so if the 4.5 fence is denied, it's basically saying you can't have this particular pool or this configuration of pool. That's not the standard though. I mean, the standard is whether other people will be substantially affected adversely or significantly affected adversely. And I mean, it certainly seemed as if people were indicating that they thought that they were. So in this sense, I would be inclined to say that showing has been made by the public comment was received.
Okay. Dave, your thoughts?
The problem I have is we're only deciding on the fence, not the pool. The people are objecting to the pool if we allow the fence. So our main focus should be about the fence. And that will not adversely affect the neighbors. The pool will, but the fence won't. So to me, that's the exception. give them the exception for the fence, because it's, the people are only upset if they get a pool. But we're not supposed to be thinking that way.
Right.
We're only supposed to think about the fence. And to me, that doesn't have an adverse effect on the neighbors. It's a fence. It's a foot higher than the other fences. I wish I could say the pool is going to have an adverse effect, but I can't.
Right.
So I would say yes for the exception, you know.
Yeah, 2 weeks ago, I went, before the meeting we had 2 weeks ago, I was in the neighborhood, and I went down the street, your street, and measured the fences, the shrubs, the height of the hedges, and there were like 4 of them were 5.5 feet, 2 were 6 feet, 1 was 7 feet. So, and then after getting clarification on what we're actually voting for, and that the neighbors, they didn't have any specific reasons that it's going to harm their property, although they alluded to the fact it's going to hurt their property value. I don't think so. So I would be in favor of allowing an exception.
Okay. And I agree. It's tough to separate the two issues, because if you don't allow the fence, you can't have the pool is what everyone's concerned about.
Right.
So it is tough. I also it's tough to separate that. I feel like steps could have been taken differently, that we might not even be here at this point. So that's kind of a hard thing to swallow as well, to separate the issues. But when I'm looking at, and as an attorney, I'm looking at the letter of the law and the standard for the exception for the pool. I don't disagree. I don't think the fence itself is affecting adversely the uses for the neighbors. The pool may, but that's not what we're discussing here. Obviously, whatever decision we made, it still has to go through the town, and has to be determined by the town that it's still within their, all the other aspects of the code. So with that said, do I have a motion?
I motion to allow the exception.
Based on the reasons stated before?
Yes.
Okay. Do I have a second?
Second, same, because of the reasons, it's like, it's no adverse effect, the fence won't. But,
Okay. All in favor? Wait, let's do a roll call, David,
Go
or
ahead.
yes or no?
I'm gonna vote no for the
Okay.
exception.
okay,
David,
yes,
you're in favor?
in favor of the
I'm in
exception.
favor of the exception as well.
And
Yes.
as am I. So that is 3-1 in favor of granting the exception for the fence.
Aye.
Well, that's why we did roll call, so, that's why I did the roll call.
Yeah.
3-1. Thank you.
I didn't hear
You
you.
got it. Okay. Based on that, now let's see, I just now a little cleanup, where's my agenda? We're just about done, we've got an officially closed meeting. Does anybody have any final comments? Okay, so,
I want beer.
I'm with you.
do I have a motion to adjourn?
A motion to adjourn.
Second, all in favor?
Aye.
Aye.